Hi, it's Carly Turner. I'm a high school student. Today I'm going to be continuing my series of AI versus copyright law, and I'm going to be talking about a case, Thomson Reuters versus Ross Intelligence, and I'm also in a separate segment going to be talking about the interview I had with a lawyer who previously worked at Thomson Reuters. So I'm using the Reed Smith article called Court Shuts Down AI Fair Use Argument in Thomson Reuters Enterprise Center GmbH versus Ross Intelligence Incorporated. So that's on Reed Smith. Make sure you check that out if you have any questions. I'm going to kind of be going over that in a second. I'm not going to be putting too much of my own opinion in this one because I kind of just want to be educating people, and hopefully this can reach a creator who's not really certain on their copyright rights. And yeah, so Thomson Reuters sued Ross Intelligence under the claim that Ross had trained its new AI legal research search engine using Reuters Westlaw headnotes. So these Westlaw headnotes summarize key points of case holdings using the key number systems, and both those things Thomson Reuters does have claimed as copyrighted work. Previously, Ross had tried to license Westlaw's content. The attempt was denied because Ross is Reuters' competitor. So they kind of turned to this AI legal research search engine as kind of a last resort to get these Westlaw notes. So, just going straight off this article, it says that Ross had tried 5 defenses, and the one that the court mainly focused on was fair use. And there are 4 factors within fair use that are talked about on this article. So, factor 1 favors Thomson Reuters. Ross's use of AI training data was commercial and not transformative. I'm going to read what they said about that. The court reasoned that the use of headnotes as AI training data is not protected as transformative use, even at the intermediate stage of product development. The court distinguished this case from previous cases involving intermediate copying of software code, emphasizing that those cases involved functional elements of computer programs, whereas the copyrighted material in this case was not out of necessity to make it easier to develop a competing legal research tool. Factor 2 favors Ross. The Westlaw headnotes and key number system are minimally creative. In its copyright validity analysis, the court emphasized that even though the quoted or paraphrased judicial opinions are not copyrightable, distilling, synthesizing, or explaining part of an opinion, as demonstrated by the Westlaw headnotes, was still deemed creative enough to constitute originality. Factor 3 favors Ross. Thomson Reuters AI training data was an insubstantial component of Ross's output product. In deciding this factor, the court considered whether Ross took the heart of Thomson Reuters' work, and if so, how much the copied material was used in Ross's final output product for the public. Factor 4 favors Thomson Reuters. Ross's product could impact Thomson Reuters' potential AI training data market. Even though Thomson Reuters, according to the court, does not yet have an actual market for AI training data, the court determined that Ross's use of Westlaw headnotes could harm Thomson Reuters' potential market for AI training data. Particularly, the court found that Ross intended to compete with Westlaw by developing a market substitute. Thus, defenses for using AI training data may be denied where there is not an established market for AI training data, but there is potential for the one. So the impact of this case, obviously, this is a big win for human creation over AI, but it is kind of different than the generative AI that I've been talking about. This is an AI legal research search engine, and it is not generative AI. And while it still is does still have big implications for how courts will handle AI versus copyright, it's it's only kind of applicable to the issue that I've been talking about on my account. But I will just kind of read what they said about the impact of the decision. As the first decision addressed fair use in the context of AI training, the Thomson Reuters decision is significant and signals cause to approach the use of data for training purposes cautiously and to adjust the risk analysis if relying on a fair use defense. However, it is equally important to recognize that the decision was decided under the specific context where Ross's final output product was a legal research search engine tool that utilizes artificial intelligence, not a generative AI tool. It will therefore be important to assess potential risks associated with the use of data for training AI with a close understanding of the AI technology itself and how these arguments may impact the potential risk analyses in context. For example, generative AI tools may have a more compelling argument for transformative use. The decision will still have implications for the rapidly evolving AI landscape, while pending in future cases will likely further address the use of copyrighted AI training data in the development or other forms of AI products. So, I mean, that's kind of similar to what I said. I did read that over, but kind of what I said before was my own thoughts. It does say a lot for this AI versus copyright issue, but this is one case and it's not fully applicable to the issues I've been talking about because it's like large corporation again versus AI instead of like actual creators versus AI. But it's still an important win for the anti AI community. And yeah, so in the next clip, I will be interviewing a former attorney who also worked at Thomson Reuters and recommended that I look into this case. And yeah, let me know how you feel about it. And for the second part of the video, I want to talk about the interview I had with the lawyer. So I'm going to be going over my questions and his answers, and I'm going to be analyzing it a little bit. So the first question I asked was just, what are your qualifications for the topic and what is your job history? So Andy Martins' JD was received from the University of Chicago Law School in 1990. He is the retired SVP of Product and Editorial for the Thomson Reuters legal business, which provides information tools and services to lawyers, judges, legislators, and other legal professionals around the world. My second question, I did give background information. I specifically referenced the Stability versus Anderson case in which Anderson sued Stability AI for recreating a work just like hers, and her name was actually, she used her name as a prompt, and AI created a work similar to it. So I asked, AI models are able to be trained using data lakes with thousands of works. In an instance that an AI's output looks similar to a copyright work that was used to train it, do you believe that that is copyright infringement? Why or why not? In a word, yes, I believe that the plaintiff's copyrights were infringed. The Constitution of the United States expressly granted Congress the power to establish a copyright system to encourage authors and other creators to invest the time and resources to create new works. And I think that part alone kind of summarizes what I'm kind of fighting for is I want artists to be protected in their work and I want them to feel motivated to create new things. So I made this page to kind of educate people on the issue of AI versus copyright, and I think the biggest thing to get from this is that artists should feel safe creating new work. And then he also said, in regards to this question, Congress created such a system protecting creators' works for the duration of their lives plus 70 years. The plaintiffs in this case allege that their work has been scraped or otherwise acquired using training images to enable the defendant's engines to produce images explicitly in the style of the training images. Allowing such use would discourage authors and creators from creating new works as the artistic style could be copied without compensation. So he's basically saying that in the Anderson versus Stability AI case, that is copyright, even though the case hasn't been settled. In a lawyer's perspective, he thinks it is infringement because their work is being copied without compensation, kind of just how I thought. So I kind of wanted to get a perspective that was anti-AI and then pro-AI, so I will be also interviewing an AI developer. Look out for that. And then he said that his legal training and experience, as well as his experience in similar litigation, such as the Thomson Reuters versus Ross case that we talked about, led him to believe that this was a serious instance of copyright infringement. And then I asked, how do you propose to protect artists and their copyrighted works while also allowing AI to grow and learn? He said, the best way to strike this balance is to enforce the copyright laws as written. I do not believe that AI has an inherent right to grow and learn, and that would override the need to protect and encourage creators. Rather, it must play within the established legal system. So honestly, this is kind of the answers I expected. He's going from the legal perspective, but he also does have some feelings that creators should be able to invest time and resources to create their works. So kind of the main thing I took away from this is that he wants the systems that were already in place for copyright to be continued through AI. There shouldn't be new rules about AI. AI is stealing work without compensation, just as a person would steal someone's work and not give compensation. And basically, he's kind of stating that AI doesn't deserve special treatment as opposed to a human who is copying someone else's work. And I think this is a very interesting perspective, especially from a lawyer. And I think it gives us kind of a deeper look into the legal aspect of everything. So, in my next episode or in a future episode, hopefully I'll be interviewing an AI developer who might have some different points or perspectives. And hopefully we can kind of just get some conflicting ideas, and then you guys can do some deductive reasoning and decide what you think is right or not right regarding AI and copyrighted work. But just to kind of like summarize everything I think that was kind of taught in this episode, Reuters versus Ross basically said that this AI and the company who had the AI model was infringing on the copyright of Thomson Reuters and copying, or not copying, but like using their copyrighted work to train their models. And even though it's not a generative AI platform, it is still a platform that is stealing copyrighted work and reproducing it. And from the interview, the biggest thing that I think I kind of, well, not learned, but just an idea that I hadn't thought of is a right of the artist to have their work protected. And just because it is a machine that's copying it and not another person who might have malicious intent, it is still hurting these artists. And AI shouldn't get special treatment just because it's an advanced technology that we're still trying to explore. So tune in for the next episode. I'll maybe post like a shorter one, kind of just while I'm doing some of my research and talk about it.